In this session, we're going to take up some of the mental illnesses that arise after a person has been sentenced to death. We've talked in another session about competency for trial and issues of insanity and so forth. Now we're going to look about at whether a person is competent to appeal or to basically drop their appeals and competent to be executed. Supreme Court has already decided that a person does not need to be competent in order for their federal habeas corpus case to be litigated. In the case of Ryan versus Gonzalez, decided in 2013, the court said that a person who's in federal habeas corpus proceedings who may be incompetent, and there were two cases, one out of the Court of Appeals of the Ninth Circuit, one out of the Sixth Circuit, that had stayed the proceedings because the petitioners in those cases were not competent. But the court said that because habeas corpus is backward-looking, record-based, the nature of it, therefore the person did not have to be competent. The lawyers could do the research, the writing, and the briefing. District courts do have some discretion. They can ask, with regard to particular issues in a case, would there be a substantial benefit from the petitioner's assistance? In other words, the lawyer goes to the judge and says, Your Honor, I need to be able to talk to my client, to have a rational conversation with my client, with him having some understanding of what's going on here to go forward. The court says a district court can grant a stay there, but that if it looks like it's going to take a long time, then the court should not grant a stay out of allowing a state to go forward and carry out its judgment. So here the practicalities say, to at least the Supreme Court, we're not going to stay in execution for a long period of time just because the person is not competent competent for trial, able to assist their client, able to assist their lawyer, and able to understand the proceedings that are going on. But there's another competency question that comes up, and that's whether or not a person can give up their appeals. That's a decision that a petitioner makes. Not unusual in some cases that petitioners decide at some point, and usually linked to mental illness, that they want to give up their appeals. In 1960, the Supreme Court decided Reese versus Payton. Reese was a case in which the case went up to the court just on a question of whether or not he could withdraw his petition for certiorari to the Supreme Court. The court sent it back in a very brief 2 or 3 paragraph opinion, a per curiam opinion, that is by the court, that said the district court was to determine whether he had a capacity to appreciate his position and to make a rational choice with regard to continuing or abandoning litigation. In other words, was he suffering from a mental disease, disorder, or defect which would substantially affect, and the words that are chosen here are very important, as we'll see, substantially affect his capacity in the premises. So that's the question that's going to be raised when a person says, I want to give up my appeals. Now, one of these cases involved a fellow named Ronald Gene Simmons, who committed a number of murders in the state of Arkansas. Ronald Gene Simmons did not want to appeal his case. And in fact, he told his lawyers not to appeal, and they abided by that. Another inmate, Jonas Whitmore, came forward and said, well, I will represent Ronald Gene Simmons, and I have an interest in this because I'm under death sentence, and the court compares cases and doing its proportionality review. I have an interest as a citizen in there being an automatic appeal. This is the only case I'm aware of where there was not a direct appeal to the state Supreme Court after trial. In most states, in death penalty cases, that's automatic, but at this time it was not in Arkansas. Well, the Arkansas Supreme Court turns Whitmore down, and he goes to the United States Supreme Court, and he loses on 2 grounds which help us understand what the court requires in these situations. First, the court said he is not injured. The fact that he's another death row inmate and that his case might be compared with Simmons' case is just simply too big a stretch. And he has to be directly injured. And this is critical for the court to have jurisdiction because this was whether there was a case or controversy before the court, that the person have to have some injury in fact. Justice Marshall pointed out in his dissenting opinion that the court did not have to enforce that and could consider this because of the importance of the public issue, but that was rejected by the majority of the Supreme Court. Secondly, and this would defeat Whitmore right out of the start, they said he couldn't be the next friend for Simmons. That a next friend has to be someone who's very close to the defendant, someone like a parent, a spouse, child, someone who's got that person's best interest at heart and who's very close to that person, not just someone who I think the court in one case referred to him as a intermeddler who's coming along and trying to decide what to do. One case that illustrates just how difficult and heart-wrenching these decisions can be is the case of Harvey and Rebecca Rumbaugh, who wanted to stand in as next friend for their son Charles. No question that they could be next friends. They were his parents, so the next friend question is not present. The question present is, could Charles make his own decision, or as his parents were pleading to the court, they're saying, our son is not able to decide things for himself and we should be able to make the decision for him. Charles Rumbaugh was 17 at the time of the offense. Today he wouldn't be eligible for the death penalty, but he was back at the time his case was before the court. He was profoundly depressed. He suffered from schizophrenia, paranoid schizophrenia. He had auditory hallucinations. He was a self-mutilator. He had tried to cut his arm off, and he had talked on occasion about experiencing the pain of self-mutilation and being cleansed by it. He was suicidal. He had attempted suicide several times, and in fact, during the hearing in federal district court, he advanced upon the United States Marshal, and the Marshal shot him in the courtroom. And he goes off to the hospital, and the hearing continues without him. Charles wants to give up his appeals and be executed, in large part because of his mental illness. And his parents are asking the court not to let him do that, but to say that he lacks the capacity to make his own decisions and they should be able to decide for him. Well, the case centers very much on the testimony of Dr. Logan, a doctor at the Springfield Federal Hospital where Rumbaugh had been sent for evaluation. And it shows how difficult it can be to determine if someone meets this standard, the Dusky standard of competence to make their own decisions in these cases. The judge is asking the doctor here, what we're all trying to understand is to what extent the depression was a coercive force in the decision that Charles made to give up his appeals. Dr. Logan said, well, if he weren't so depressed, if he didn't have bouts of paranoia, if he didn't have auditory hallucinations, he probably would go forward with the litigation. So obviously there's a very direct relationship between his depression, his paranoia, his hallucinations, and the fact that he wants to give up his appeals at this point. Dr. Logan says his mental problems affect him. This was the question asked in Dusky. Does it affect his ability to make a decision? It affects him to the extent that if he were not so depressed, if he did not have the periods of paranoia, were his periods of auditory hallucination not present, and if he wasn't so hopeless about his position, both his mental health condition and his hope of ever winning his appeal, he might be able to better cope with spending time on death row and waiting and seeing how his appeals turned out. But his mental condition would not permit him to do that. He goes on to say that his mental condition influenced him to a certain degree, maybe even to a substantial degree. He recognizes that his mental condition is deteriorating. It's a realistic assessment. It is deteriorating. It influences him. He's been miserable for a long time, and he's going to be miserable for a long time, and he understands that. And he's able, nevertheless, he's able to think coherently. So the judge analogizes this to someone who has cancer that doesn't want any more treatment. He's miserable because he has all these mental illnesses. He's going to continue to be miserable because there's very little prospect that he's going to improve in terms of his mental condition. Of course, most people who are in prison, who had this feeling of hopelessness because of their depression and their schizophrenia and their self-mutilation and so forth, of course, would not have the opportunity to have the state put them to death. Only because Rumbaugh is on death row is he able to have the state carry out his execution and end his life. The court asks if he's able to understand what's going on. No question, he understands what's going on. The court asks, is his decision rational based on what he presently faces? Now, this is a court asking, is the decision that Charles Rumbaugh is making rational? Well, that's probably, anyone could say that whether the decision was rational or irrational, and probably reasonable people would disagree about that. But Dr. Logan says, yes, based on his past experience and based on what he presently faces, I believe it's rational or logical, at least. So is the fact that it's logical for a person who has terminal cancer not want treatment? But this, of course, is not treatment. This is being executed. Is it rational or logical for a person who's facing execution to decide that life is so miserable that they don't want to go on and therefore they want to give up their appeals? The court employs 3 steps, the majority. This is a 2-to-1 decision of the United States Court of Appeals for the Fifth Circuit. 1, is the person suffering from a mental disease or defect? If no, you stop right there, but in Rumbaugh's case, there's no question. He's suffering from all kinds. He's depressed, he's schizophrenic, he's got major mental illnesses that may substantially affect his decision. So go to step 2. Step 2, does the mental disease or defect prevent him from understanding his position? Again, the answer here is no. Rumbaugh understands his position, has a good understanding both legally and factually of where he stands in the legal system. We go to step 3, even if he understands his position, does the mental illness, and the judge asks the question now, prevent him? Not does it influence him, not does it affect him, but does it prevent him from making a rational choice among the options? You could state those last 2 questions as Reese did, whether they substantially affect his understanding of his legal position and the choice that he has before him. At any rate, Dr. Logan says there's no question the severe depression has some influence on his decision to give up his appeals. He's capable of appreciating his position. He understands where he is, that he's in court with a habeas corpus petition. He can go forward on it or not, and that he can make a sufficiently and substantially rational choice with regard to abandoning further litigation in his case. The court allows Charles to take over the case, dismiss it, and he's eventually executed. Judge Goldberg dissented. Judge Irvin Goldberg says, wait a minute, competency is a mixed question of law and fact. That means a blend of the facts as we have them in the record, but also the law of competency, and the court thinks that Justice Goldberg thinks that the court defers too much on the question and doesn't analyze it enough itself. He says, if you look at this carefully, what Rumbaugh is doing is taking logical steps towards a goal that is the product of his mental illness. This is a question of a man giving up his appeals because he is mentally ill. And he's unable to determine what's in his best interest. His mental illness keeps him from deciding what's in his best interest. Well, it was a very close case, a very disturbing case for the parents, for everybody involved, but it shows how difficult these decisions are. in deciding whether or not a person has the capacity, that is, the ability to make their own decision, or whether it's influenced by the mental illnesses, particularly if you have the profound and deep mental illnesses that somebody like Charles Rumbaugh had. But those are the questions that courts decide. Possibly different judges would have come out in a different way on this case, but as it turns out, Rumbaugh loses. His parents are not allowed to step in and represent him, and he's put in the state of Texas, puts him to death. Look at these terms that are critical in this analysis. Prevent, product, or effect. Did the mental illness prevent him? I would say the mental illness, he can't understand what's going on because of the mental illness. Or is his decision a product? Do we really know what the product of mental illness is? Is the decision a product of the mental illness? Or does the mental illness substantially affect his capacity to understand? If you ask these questions differently, you might get different answers, because with Rumbaugh, you might say that his mental illness does substantially affect his capacity. Maybe not so much to understand, but to make a rational and informed and intelligent decision with regard to giving up litigation or going forward. But this is the sort of parsing that the courts do in this very mysterious area of mental health, where very often there are different doctors giving different diagnoses and different opinions about the abilities of people who suffer from mental illness. Well, another place where mental illness often can come into play is with regard to the execution of a person. Many people on death row may have already had mental issues in their case at trial, but some people will deteriorate significantly over the time period that they're on death row. It's not a healthy place to be, and they may be in virtual solitary confinement during much of that time. And so the date of the execution approaches, the cases have been decided, and it becomes apparent that this person doesn't understand what's going on, that they're in a whole different world of reality in which they either don't know they're going to be executed, or they don't understand what execution is. We looked earlier at a case out of Arkansas, Ricky Ray Rector, who, after he was executed, they go back to Rector's cell and find that he's put his pie aside. He thinks he's going to come back after the execution and have dessert. So he obviously had very little understanding of what an execution was and the finality of the execution, or what death was. But of course that evidence didn't come out until after the courts had already held that he was competent to be executed. So we'll look at a couple of cases where the Supreme Court has dealt with this. One, Ford versus Wainwright, where the court first deals with both the procedures required and with the definition, and then after that, Scott Panetti's case out of Texas. Alvin Ford versus Louis Wainwright was the first case to present to the Supreme Court this question of whether or not a person was competent to be executed. It was an open question at that time whether the Constitution prohibited the execution of a person who was insane, as it was put forward in that particular case. The court canvassed what had been the practice in jurisdictions in the United States, different states, England, and came to the conclusion that there was a constitutional prohibition to executing someone who was insane. But we're going to see the devil is in the definition in terms of how we describe that. But the other issue that Ford had was he was claiming that the way in which it had been done, the way in which he was determined to be competent, did not measure up to due process standards. Alvin Ford was a person who was clearly suffering from delusions, both in his speech patterns and what he believed. His lawyers really couldn't talk to him because he didn't speak a coherent English when he was talking to people. So the state sends some doctors down, examine him. They won't take any information from Ford's lawyers about what his mental condition is. and it goes to the governor, and determination is made there within the executive branch that he's competent, and Bob Graham, the governor of Florida, signs a warrant to put him to death. Supreme Court says you got to do better than that. First of all, the person who's about to be executed, that person, their lawyer, has to be involved in this process. If they've had a mental examination and want to put that before the fact finder to determine whether he's competent, they have a right to do that. If they have lay witnesses to testify, the court doesn't say that, but they have a right to do that as well. People who've watched this person and who've talked to this person and have some sense of what this person's understanding is. If the prosecution is going to put forward evidence, perhaps it's subject to cross-examination, as in most kinds of cases where decisions are being made. And finally, the decision maker has to be more objective. It can't just be somebody in the governor's office. So as a result, we find that the way in which Ford was determined to be competent did not meet constitutional standards. I mean, this is as basic as the case of Goldberg versus Kelly, which talks about what kind of procedures a person's entitled to before their welfare benefits are terminated. Here we're talking about a much more serious decision, not that that isn't a serious decision for many people, but whether or not Alvin Ford's life is going to be taken. But then the question is, what does it mean to be insane? Justice Marshall doesn't write much about that in his opinion, which was for 4 members of the court. Justice Powell cast the 5th and deciding vote. And in his opinion, he says the 8th Amendment forbids the execution of those who are unaware of the punishment they're about to suffer and why they are to suffer it. The American Bar Association has suggested a slightly different standard, one that the person understands why they were tried, what the proceedings were, and the reason for their punishment. That's not much different than what Justice Powell said. But secondly, that the person lacks capacity to understand what's going on and to be able to communicate with their lawyers about what might make unlawful or unjust their execution. It seemed pretty clear that after Ryan versus Gonzalez, that is not necessarily required, since the court, although this may be a case where the person's cooperation is critical, but of course the whole issue is competency itself with regard to deciding that. Some states have adopted the American Bar Association's test, but for our purposes we'll look at what Justice Powell said. The person has to be aware of the purpose of the punishment and then why they are receiving it. I am going to be put to death because I was convicted of murder in this court many years ago, whatever rudimentary understanding the person has of it. And so many people can be profoundly mentally ill. It's proven to be, can be profoundly out of touch with reality and still be found competent for execution. One case that illustrates this is the case of Scott Panetti, who was sentenced to death in Texas. Panetti's mental health problems were obvious from the outset. He tried his case in a cowboy suit, like a little boy would wear. He was found competent for trial, allowed to try his own case instead of having a lawyer try the case. People that watched the trial said that those who were there were afraid of him, were worried about what he was going to do. He clearly was not functioning as a normal person during his trial, and his mental health didn't get any better during the time he was on death row. By the time Texas was about to execute him, Scott Panetti was suffering from a genuine delusion, according to the court, that his execution was part of spiritual warfare between the demons and the forces of darkness on one side and God and angels and the forces of light on the other side, and that he was going to be executed to keep him from preaching. And that was basically his understanding. In other words, he did not understand that he was going to be executed for punishment for the crime he committed. He understood what execution was, but the purpose he saw it being as to keep him from preaching. not as punishment for the crime that he committed. Supreme Court, in a decision by Justice Kennedy, says that the lower court should not have left out, not considered this delusional belief. He also found that the procedures leading to the finding of competency in Panetti's case were totally inadequate by the Texas courts. But we'll talk about what he said with regard to Panetti's competency. The argument that Panetti suffered from a severe documented mental illness and had gross delusions preventing him from comprehending what was going on, and the purpose of the execution had to be considered, and the lower court had not done that. So the court reversed the case, sent it back. The Fifth Circuit in turn sent the case back. The Court of Appeals of the Fifth Circuit sent the case back to the district court. Judge Sam Starks had a hearing, once again found that Scott Panetti was competent to be executed, that he had a sufficient understanding of what execution was and what the purpose of it was as well. This standard does not keep profoundly mentally ill people from being executed. John Ferguson was executed in 2013 by the state of Florida. Ferguson had an unusual belief system. He believed that he was the Prince of God and that after execution he would be resurrected and he would return to earth in that capacity. Here there were many aspects of his mental illness, but with regard to that delusion, here's what Judge Ed Carnes said for the 11th Circuit, that thought about what happens after death might seem extreme to some people, but he pointed out that every world religion, from Christianity to Z, believed in some kind of continuation of life after death and some kind of resurrection. So Ferguson's belief that he's going to be resurrected, the court said, it's not all that different from the views of millions of Americans with regard to their religious beliefs. A decision's almost self-parody in terms of treating a profound mental illness as nothing but an unusual religious belief. John Ferguson was executed by Florida on August 5th, 2013. And his case tells us a lot about the mental condition that a person can be in and still be executed in the United States.